All right, I think we are live. We'll wait a second here and see if we're actually getting, oh, I guess we have the word. We are in fact live. All right, so good afternoon. It is Saturday, November 17th, and we are live here on Crime Talk. We have been discussing over the last several weeks the Christopher Watts case, and for those who don't know, Mr. Watts is accused of killing his wife, who was 15 weeks pregnant, and his two younger daughters. And he came up with a story that basically his wife had disappeared with the children and had no idea, and ultimately that story fell apart, and he confessed to killing his wife, Shanann, but stating in what's stated in the affidavit for arrest warrant that he did not kill his daughters, that his wife, in fact, had done that. And then last week, Mr. Watts pled guilty to all 9 counts of which he was charged with. He had 3 counts of murder in the first degree, another 2 counts of murder in the first degree, which were position of trust, basically killing a child in which he had a position of trust under Colorado law is basically that he was responsible for their well-being and welfare. Then he was also charged with another count of unlawful termination of pregnancy, which was a Class 2 felony, which carries 16 to 48. And then 3 counts of tampering with a deceased human body, which were all Class 3 felonies, which carry a presumptive range of between 4 to 12 years in the Colorado Department of Corrections. All 3 of the murder counts by law have to be consecutive to one another, and there was also an agreement in the plea agreement that count 6 would also be consecutive. So basically, we know for certain that Mr. Watts will receive 3 consecutive life sentences as things sit right now, and 48, well, a range of between 60 to 48 years. I'm assuming the judge that he is in front of for sentencing, Judge Kopkow, will probably give him 48 years for that, because frankly, it's somewhat academic at this point whether he gets 1 life sentence, 2, 3, 4, plus 48 years, etc. It doesn't really matter. The other counts, the other counts 4 and 5 for the position of trust, those will merge with counts 2 and 3, and so it's the same, really the same offense. So by law, they have to go run together. Now, the things have been getting interesting. We had a video that we put out and basically asked, did Chris Watts get punked? And the thought behind that was simply, did he really get a deal? And a lot of people were upset with my opinion and analysis on that. Other people agreed with it, that Mr. Watts was not really getting a deal. And I said, from a defense attorney perspective, which I've made no secrets about that I am a defense attorney. That's what I have done for some 24 years. That if my client was told to, plead guilty straight up, chances are I was going to say, prove it. Now, in this particular case of Mr. Watts, he was given the concession that the death penalty would be taken off the table. And my position was, is that really a good deal to plead guilty to all 9 counts straight up? And on top of that, are you really even getting any kind of concession? Because the death penalty has really not been implemented here at all in Colorado in a long time. It's unlikely that it will be done in any type of fashion over the next 10 years. And even if you are ultimately convicted and sentenced to death, it's going to take another 20 years of appeals, not only in the state and federal court, for that process to be resolved. And so, my thought was, did you really get an offer? My analysis was, and it's very straight simple, is that when you bargain, you plead guilty, you get something in exchange for it. And, are you really getting anything with the death penalty? Like I said, chances of being implemented in Colorado these days are about slim to none. So basically pled guilty. But understand, that is Mr. Watts' decision, all right? The attorneys aren't going to be able to plead him guilty. They can't force him to plead him guilty. And in fact, the colloquy between the judge and Mr. Watts is clearly going to show that he was entering his plea freely and voluntarily. And I have had many people contact me, my office, or online and ask whether I would represent Mr. Watts. Well, what can you do for Mr. Watts? That's the big question. He has pled guilty, and there is a mechanism whereby people can withdraw their plea prior to sentencing, but that has to be done, like it says, prior to sentencing. Because after he is sentenced, then your only remedy is what they call a Rule 35C. And at that point, you have to say, be able to show that your attorneys were ineffective. And that's a very tough standard to get through or over, simply because, basically your attorneys are presumed to be competent. And here in this particular situation, if you plead guilty, you have the transcript between the judge and Mr. Watts. And I can tell you, we hopefully will have that transcript over the weekend. The request was put in last week shortly after his plea, and the court reporter was somewhat hesitant to give it to us because it had to go through the chief judge, and I had to explain that we have a vlog that we're doing, and we wanted to make sure that we accurately reflected what was in the transcripts so that we don't misstate anything. So it's, we cover accurately what was stated, what's in the transcript. And my office manager hand-delivered a check to that court reporter yesterday, and it's my understanding we should have it hopefully here via email sometime this weekend. I'm still waiting on it. I'm looking forward to it. I'd love to see the colloquy, because obviously we weren't there and there was no media coverage in the courtroom whatsoever. So the best and most accurate evidence that we're going to have of that is in the transcript. So we should have that. But in that transcript, it's going to be the judge, and this is standard in all cases, in most cases, the judge will go through what they call the Rule 11 advisement, whether it's state or federal court. And here we had a copy of, and we went through in one of our videos, the Rule 11 statement. And, it says these are the rights you have, every defendant, okay? Whether you're charged with murder or a traffic ticket, everyone has the following rights. That you have a right to enter a plea of not guilty, to make the prosecution prove the case beyond a reasonable doubt to each and every element of the offense charged. At a trial, you have the right to assist in the selection of the jury with your attorney. You have a right to confront and cross-examine your accusers, all right? That is probably the greatest truth-seeking tool ever invented, the confrontation clause of that's in the United States Constitution. You have a right to confront and cross-examine your accusers. Through your attorney, ask questions. At a trial, you have a right to present a defense you might have, okay? You can say it's just a simple general denial. Didn't do it, prove it. Or you can say, I did something, but I had a legal justification or excuse for that. Or the defense is, I did it, but I didn't have the requisite mental intent that you have charged. Obviously, first-degree murder is with deliberation, after deliberation. You can say, no, I just did it, but I was in a rage and heat of passion, and so that provides for a lesser charge of second-degree murder, which obviously carries not a life sentence, all right? So going back to the rights, you have a right to present a defense. You have a right to call witnesses in your own defense. So if there's any witnesses who wouldn't come voluntarily, you have a right to subpoena them, and they would be forced to do that. And if you couldn't afford it, the state could pay for those expenses if necessary. And probably most importantly, every defendant has the right to testify at a trial, okay? No one can prevent a defendant from testifying or not testifying at a trial, okay? And here in Colorado, the courts will give what they refer to as a courteous advisement. It's based after a case, and the judge will have an exchange prior to the defendant testifying, before the really the beginning of the defense case in chief, if there is one presented. And even if there is not, the judge goes over it, so he makes sure that every defendant understands it. It says, do you understand? You have an absolute right to testify. You should listen to your attorneys, but you do not have to follow their advice. It's your decision to testify. And the judge will make sure whether that's a knowing voluntary decision, and whether they're under the influence of any drugs or alcohol or any medication that would affect their ability to think clearly. And then the judge would also ask the prosecutor what, if any, felony convictions may exist, because they would be subject to cross-examination. So for example, normally if someone has a felony conviction, that information will not be heard from by the jury unless the defendant testifies, okay? And so the defendant needs to be advised of that would take place. In this particular case, Mr. Watts had no criminal history, so that is not an issue at all. And so the court will go through this colloquy, ask if the defendant's made a decision whether he wants to testify or not, and the defendant does not have to make that decision until the end of the defense case in chief. So if they have a bunch of witnesses, he may say, you know what, I have all the information to the jury that I wanted to get out without me having to testify, okay? And then the judge will ultimately tell the defendant that if you choose not to testify, I will instruct the jury, if your attorney requests the instruction that says the defendant never has to testify, he cannot be compelled to testify, and that you cannot consider his silence in any way, okay? I can tell you from a defense attorney perspective, I have won more cases when the defendant does not testify, because jurors, in my opinion, take their jobs very, very seriously. Jurors will, for the most part, this is probably the biggest decision that they've had to ever make in their lives, so they're going to take it very seriously. They're going to look at the evidence. And when the defendant doesn't testify, my experience is that they look overall at all of the evidence or the lack thereof, versus simply when the defendant testifies, did I believe his story? And they can look at him and say, oh, he has beady little eyes. I don't like him. I don't like that tattoo. His tie. For any reason, they can say I don't like him. It could be just the nature of the charges in and of itself. So that's something to consider. And then if the defendant does not testify, that instruction ultimately gets read to the jury, all right? But the judge goes through that process, and all that would be explained in the Rule 11 advisement before he went through it. And then the judge also asks whether the defendant is satisfied with his representation, okay? And most judges are very, very adamant about that. They'll say, I don't care what anybody's told you to do. I want to know, are you satisfied with your advice of your attorney, okay? And the judge will ask them, and if you are not, then we're not going forward. They'll ask them, what do you think your attorney should have done that they didn't do? Was there witnesses they shouldn't have talked to or should have talked to? Was there evidence that should have been called into question? Experts that should have been hired, okay? So that's how the judge will go through that. And that's why it makes the question of whether Mr. Watts, if he wanted to withdraw his guilty plea, so difficult, simply for that fact, that colloquy. They go through that so people don't get buyer's remorse, and we would never, ever get that done, all right? Now, the other thing that's going to be interesting, and we have put a request in, and that is for the autopsy report. The autopsy is going to be so telling in this particular case. And normally, as an attorney, or just about any everyday citizen, you could go down to your local coroner and say, I would like to get the autopsy of whomever, okay? And they'll give it to you. You pay your fee, you're on your way. And in this particular case, the defense didn't object to it, but the district attorney didn't want it released, and they fought for it not to be released, which is very unusual because this is a public government record, and this is the record that belongs to the people. It's the truth. And the district attorney's position was that they were going to not authorize the release because it could affect the jury pool, taint the potential jury pool, which I think is absolutely, absolutely ridiculous. And we, it's simply, it should be released. It is a public document, all right? And, sorry, I lost my train of thought right there. Anyway, so the autopsy should have been released. DAs fought for it to be released, and the court actually had to be told by the news organizations that filed for access to that autopsy that the court and the DA had no authority to prohibit that. And so the coroner in this particular case then filed a separate action in district court, and responses were filed mostly by news organizations, basically saying, no, you have to turn it over to us for basically the reasons I just told you. There's nothing that far outweighs the public interest here that it shouldn't be released, okay? I don't buy the fact that you cannot get a fair and impartial jury. There are so few cases. Weld County is relatively large, and the remedy, if you get to jury, you get to the jury pool, and if the judge hasn't granted a motion for change of venue, which rarely happens, if you get those jurors in there and you come to the conclusion, wow, we're not going to be able to get a jury, then you move the darn thing. Okay, I have a case pending right now. Small town, Colorado, everybody knows about it. Preliminary hearing transcripts have been put up by the press on their websites. It's the last murder that took place in this town in Colorado was 30 years ago, and it was the U-Haul trailer case. So it's the biggest thing. They haven't had a murder there in, I think, 32 years. So it's a big deal. Everybody was following it. Everybody talked about it. Every time we sat down for dinner, my attorney, my associate, and I were asked if we were the attorneys on the case. Everybody knew about it. The judge agreed, not going to get a fair trial. And so that's the case. But here in eastern Colorado, on the plains, you're going to get people that, I know, you're going to say hard to believe, there are people out there that have not heard of the Christopher Watts case. It's not that big a deal. You could find jurors. And just because you've heard about something doesn't mean that you can't be fair and impartial, okay? It's an allegation. The government still has to prove it. And if you can find 12 jurors plus some alternates that can listen through the evidence, reserve judgment until they hear all the evidence in the case, and then follow the court's instructions, you're going to be able to find a jury that can deliberate and hear this case. So I think the government's argument, as well as the coroner's argument, were misplaced, and for whatever reason, they just didn't want to turn it over. But when Mr. Watts entered his guilty plea, we contacted the coroner and said, well, he's pled guilty. I would like to get a copy of the autopsy report. The coroner has instructed me, actually, just to be accurate, instructed my legal assistant that the autopsy will be released 24 hours after Mr. Watts has been sentenced. And the hearing for the release of that autopsy report is still set for next Friday. So I think it's the 26th or something like that. Anyway, so we're going to get it, and everyone's going to see exactly what the cause and manner of death was to Shanann and her children, and so we're going to get that. Now, there's been lots of rumors out there that the autopsy report's been leaked. I personally have not seen that. I have not seen a copy of the autopsy report. If I did, I would love to see it, and I would, share it with you all, because you all have a right to know, just like everybody else. So ultimately, the question is, what?
Read some of the comments. And
Oh, okay.
respond to them.
All right.
Just say, let's look at some of the comments.
Yeah. All right. Let's take a look at some of these comments that are coming in here. Let's see if I can make that. Let's see here. Dana, Davina, you're sweet. Thank you very much. Plain talk. How do you do that with the screen name in block red? I have no idea what that means. But all right, read your comments here, Scott. Whatever that. Here, Scott, in reply, we spend our time, which is not easy to find, watching these and interacting with you. Not all of us like DD 15 years with no job. What are your thoughts on the exact day in the arrest affidavit of the girl's death? Paula's question. As the cause of death, really, we don't know. We know from the arrest affidavit that Watts said that he killed Shanann in a rage because he's alleged that Shanann had killed the children and he was upset about that. Who knows? All right, we know there were 4 people in that house at that particular time. Mr. Watts, Shanann, and his 2 daughters. We don't know if anybody else was there. We simply do not know. So the question then becomes, are they going to be able to determine time of death? Were these kids killed before Shanann got home when she arrives roughly at 2 a.m. on the 13th? Or was it all kind of one after another? We still don't even know the manner of death. Strangulation, was there, bludgeoning, was it, we simply do not know. And so we need to, unfortunately wait and be patient and see what is going to take place when we get that. It may be absolutely earth-shattering. Everyone's going to say, oh my gosh, this is the case where it was defendable, or, oh my gosh, he is the most horrible human being and he should rot in hell. That autopsy is going to be key. It's also going to be interesting what the coroner was able to find as it relates to the bodies, because as we know, the girls were placed in an oil drum, and it really just depends what they were able to determine based upon that. So it's going to be interesting to see. Another comment here is, what about the stomach contents of the girls? Stomach contents is there, but that's not that accurate. It's not going to be able to say the time of death with any certainty. Any good coroner will tell you that unless he actually witnessed somebody, or there's an eyewitness to the fact that somebody was killed at a particular time, a good coroner will only be able to tell you that it happened within a range of a time. And the stomach contents in and of itself is not going to be some decisive factor there whatsoever. Stephanie had a question. Can an attorney file a plea at the last minute before the hearing? Yes. Up until the time of sentencing, Mr. Watts could request that he withdraw his guilty plea. Is he going to do that? He's the only one that really knows. And the question is, what does he know? We talked about this earlier. Apparently, according to his mother, when statements were made by her this past week, is that he's basically kept in solitary confinement, for his own safety. What kind of access is he getting to the news? What kind of access is he getting to outside information or people? And I understand why his attorneys are limiting access to him, okay? And this is a big misconception, a big misnomer that people have, is they think, well, the only thing that matters is what he said to the police. No. Anything that a defendant says can and will be used against him, all right? And it's not just to the police. It's not after you've been advised of your rights. It's anything that you say to anybody. So if you tell a deputy sheriff who's working there that, yeah, I didn't mean it, or talking, small chat, a cellmate, whatever, it is the kind of situation where that person can go and say, Mr. District Attorney, let me tell you what Mr. Watts said. So there is a method to the madness by not wanting him to speak with anybody. But it makes you wonder, what does he know? Okay, the attorneys, I'm assuming, unless he said he didn't want to see the information, has gone through the discovery that's been produced today. This kind of case, though, is something that it's always ongoing. I started trial in a couple of weeks in federal court, and you would think, well, they'd have it all be done. Well, guess what? They amended charges, and I got another CD full of discovery. So I can't imagine that everything in this particular case was done just yet. But the important things were, and like I said, I mean, here's the thing. Mr. Watts is the one that made that decision. Nobody forced him to do it. All right? The judge wouldn't have said that he wanted to do it. Let's see. Lillian says, allegedly there was no blunt trauma to Shanann. Autopsy showed she was brutally beaten and strangled. This information came from SESH channel. I need to give credit. If, that were the case, like I said, I don't know. I don't want to necessarily speculate on something I haven't seen. And, even if that's the report, it doesn't necessarily mean that other experts would, in fact, agree with that. It would just, we'd have to see it. And, obviously we'll be able to get the reports, and we may, it gets a little more difficult if you're not related to the case to get the actual autopsy photos, because the coroner will take hundreds, if not thousands, of photos in these particular cases, and they will do everything to look for cause of death, manner of death in these autopsies. And if there's one thing that ever happens to me, please do not ever let them do an autopsy on me. It is absolutely the most hideous thing ever. All right, I have another question. Is can the parents have a victim impact statement? Mr. Watts' parents, okay? Interesting question. All right, let's take a look at this, because on, I believe it's Thursday afternoon, there was an order that came out by the court. And the court, this order is dated November 15th. So what was that, yesterday? Nope, 2 days ago. 2 days ago. It says, on November 14th, private counsel on behalf of Cindy and Ronnie Watts requested the filing of an entry of appearance in the above referenced manner. Cindy and Ronnie Watts are the paternal grandparents of Bella Watts and Celeste Watts. The paternal grandparents are, quote, victims pursuant to Colorado Revised Statute, section 24-4.1-302, paren 5. While not parties to the case, the paternal grandparents are afforded all the rights encompassed under Colorado Revised Statute 24-4.1-302.5 as a crime victims of the child victims. These rights include making a written and/or oral victim impact statement. At the sentencing hearing scheduled for November 19th, 2018, this court will afford the paternal grandparents or their designee, should be an opportunity, not and, so even the courts make mistakes, an opportunity to deliver a victim impact statement. The court does not authorize the acceptance of the entry of appearance. So, yes, so let's talk about sentencing. Okay, first of all, assuming Mr. Watts doesn't make an attempt to withdraw his plea, this normally what will take place is at a sentencing hearing, the judge will allow either the defense to present witnesses or the prosecution will be allowed to present witnesses. It's uncertain. Frankly, the only ones that would know at this point would be the district attorneys, the victim advocate, and maybe Shanann's parents and family, whether they're going to speak directly to the court or whether they will deliver basically a written statement, which they are entitled to do. They don't have to do anything. And they won't be allowed to speak directly to Mr. Watts. If for some reason they're making their statements and they start looking and speaking directly to Mr. Watts, the court will stop them and say, no, you need to address your statements to me. The district attorney will then make their statements and make their recommendation for sentencing, which a lot of it, like I said, is academic. He's going to get 3 consecutive life sentences plus the 48. Counts 4 and 5 will merge. And then the tampering of the human body, whether those are run concurrent or consecutive, like I said, really doesn't matter. At that point, then the defense will be allowed to make a statement in mitigation. And understand the defense doesn't have to do anything. Ultimately, if the defense calls any witnesses, then those individuals will be given an opportunity to speak. Now you have to understand the defendants, Mr. Watts, he's pled guilty at that point, and if they're going forward, it's all about acceptance of responsibility. So if he gets up and says, I didn't do this, I pled guilty, they forced me to do it, etc., that's not going to carry a whole lot of weight with the judge, and all of a sudden those sentences that could be run concurrent, probably get maxed and they run consecutive. So, at that point, if he's going to go forward with it, he should probably either keep his mouth shut or simply apologize and say, I accept full responsibility and I'm a horrible human being, and take his stuff and go away to DOC and be done. All right? So if the family wants to do it, once again, be careful what you wish for. You may not be doing anyone any favors if you get up there and say he's been railroaded, he didn't understand, he didn't know. If he's not the one personally making that statement, then it could really backfire. So that's what we need to, we'll all be there. We'll have to wait and see. The court granted the expanded media coverage. There's going to be one video camera in the courtroom. There's going to be one still photographer and reporters as they see fit. And they've actually moved it to a larger courtroom, and they're allowing streaming into the courtroom where it was originally set. It's uncertain whether there'll actually be live TV on it, but I actually think there may be. And let's go back to some of these comments. Will he go to prison directly after sentencing? Yes. What will happen is he'll be taken back, and usually the counties do their DRDC run, which they refer to it as, because they have the Denver Regional Diagnostic Center, which is down in Denver. He'll be taken there. They'll classify where Mr. Watts will need to go based upon his education, any kind of rehabilitation, length of sentence. Obviously, he's never getting out. And so they'll probably send him to one of the prisons where they send a lot of people where he doesn't go. He'll either go down to Canyon City, CSP, maybe for his own protection for a little while, but eventually he'll have to get out. Or they'll send him to Lyman. But you have to remember, he's not anything special to anybody else in the Department of Corrections. He doesn't necessarily deserve any kind of protection unless there's been something negotiated between the the Department of Corrections and the district attorney whereby they'll maybe house him out of state, but I'm not aware of that. There's been no indication of that. He should basically go and possibly be in general population as soon as he gets there. Like I said, there's lots of people in prison that have done bad things for killing women and children. So he's not special. He's not going to be able to say, oh, I'm Christopher Watts, please take care of me. He's no different. There's lots of very bad people. So a lot of good people have made some really poor choices, but ultimately there's nothing that's going to protect Mr. Watts from anyone else in there other than if he checks himself into protective custody, but that's not going to last forever. He's got a lifetime to go. He's 30-something years old. He's got a ways to go, at least another 30 years, assuming the average life expectancy in the Department of Corrections, I believe, is about 62 years. You're not exactly going to get the best physical care. You're not going to get working out at the gym, etc. Your life expectancy isn't that great for somebody with a life sentence. So, question here from Robin: can he appeal after the 19th if he pleads guilty? No. One of the things I forgot to say was when you plead guilty, you give up all of your appellate rights. There's nothing to do. You've pled guilty. Okay. The only thing that could be appealed was if the judge gave an illegal sentence, which the judge is not going to do. He's not going to give him multiple life sentence, going to give him a sentence he can't do. So no, there will be no appeal. Let's see. Would he be considered in his right mind if he was under suicide watch, and that would have a bearing on his plea? Suicide watch people in custody is not that big of a deal. It happens all the time. People, whether they're there because they think their life is crumbling, they just think their life is over and what have you, and then they watch them and then they don't hurt themselves. Frankly, if they were going to do it, they'd have time to do it. That is not necessarily something to say that they were not in the right frame of mind. And once again, when Mr. Watts pled guilty, he simply, if the judge had any concern as it relates to his well-being, his state of mind, he wouldn't have allowed the plea. All right? I have a question here. What about the fact that he did not get a psychiatric evaluation before pleading guilty? Well, how do we necessarily know that didn't take place? We don't. The attorneys on the case may have had him interviewed by a psychiatrist early on for mitigation purposes and to see whether he was competent. If he wasn't competent to stand trial, for example, whether he was on suicide watch, he couldn't assist in his defense, something along those lines. And we don't know that that didn't happen, okay? If it didn't happen, it would kind of surprise me just given the nature of the case, but it doesn't necessarily mean it affects anything. And like I said, if you get sentenced, the only thing that they can do afterwards is do a 35C, and that's basically trying to say that his attorneys were ineffective. But then you not only have to show that they were ineffective, that their standard of performance fell below that of basically an average attorney, but that it would have affected the outcome of the case. And so that's why it is so difficult if he does not attempt to withdraw his guilty plea before Monday, or at least ask for it, and then the matter be set out, and the new attorney could investigate and move on. I've been retained and even looked at cases, whether there's a basis to withdraw a guilty plea, looked at the evidence and said, what are you doing? You got good legal advice. You should take the deal, okay? But people get that buyer's remorse. They talk to people. You never know what's going to happen. Let's see here. Recovering Baptist. I despise Chris and his parents, yet the parents should still have the right to speak. Absolutely. I mean, if the defense attorneys want them to. I mean, it sounds like the judge is going to allow his mother and father to speak as under the Victims' Rights Act, so be it. It may not be what the defense wants to hear. It may not be anything that's actually going to help, but under the rights here in Colorado, he will have that. So, let's see here. Ann Hicks, would you take his case if he changed his plea? Well, you know, at that point, I mean, everyone is entitled to a defense. Everyone is entitled to counsel of their choice. And if you cannot afford to handle the expenses associated with that case, then, you know, they need to stick with the public defender's office to do that. A case like that would be very expensive. Possible experts, we're talking hundreds of thousands of dollars in expenses. So it's simply, you know, would I represent him? I believe that everybody's entitled to a defense under the Constitution. It's guaranteed to rights of counsel, but I also have a business to run, and paychecks don't magically appear unless there is money coming in. That's just the reality of it. Ultimately, we have a business. We do take cases, you know, when the court asks us to, but it's the kind of thing where it's, you know, we have a business to run as well. So possibly, if the retainer was met, so to speak.
Plain talk.
So, all right, I think we've talked a little bit. Hope I didn't talk too much. Hope you enjoyed it. I appreciate all your comments. If you like it, please. Oh, got a comment here. Let's see what this is. Someone's handed this to me here. Can you clarify something, please? As I understand it, last week was basically his intention to plead guilty. Monday's actual plea. Is that correct? No. He has pled guilty. What I talked about, where the Rule 11 advisement, I have the paperwork, where Mr. Watts signs, initials, and says he understands the rights he has, rights to giving up possible penalties. Judge went over that. Here it is, written waiver and guilty plea. He has pled guilty. Monday is the sentencing, okay? And frankly, this was set over simply because the family, the district attorney wanted it set over. Normally when somebody is found guilty, whether by plea or a trial of murder in the first degree, they don't set it over. There's no pre-sentence investigation report. It's simply, all right, there's no other sentence I can give you, send you on your way, you know, life in prison, see ya. So this was set over for the family to speak. You know, more than likely, everyone needed time to collect their thoughts, given the attention that this case has received. But no, he has pled guilty. He is being sentenced on Monday. The only thing that would possibly change would be, like I said, if he retained new counsel entered their appearance and asked to continue the sentencing and for further time to investigate whether there's a basis in which to withdraw his guilty plea. All right?
Why destroy the evidence?
Let's see, question, the evidence, all right? So normally these take cases, and it depends on the jurisdiction, all right? But in this particular case, they being the district attorney and the defense, an evidence disposition, stipulation, and order. And basically it states that, I'll read it just so it's clear, so nobody has any misunderstanding here real quick. The defendant understands that evidence being held by law enforcement agencies in this case could contain DNA. The parties stipulate, and then there's a box either yes or no. The defendant's identification is a disputed issue. No. The law enforcement holds evidence that contains DNA. No. Evidence that has not been tested could be subjected to DNA test. Yes. All right? So there's already something there that's been tested. The evidence in this case includes DNA evidence that should be preserved. And then the box checked no. It says the defendant pleaded guilty to the following crimes. It lists all the crimes. And it says evidence log provided in discovery. There's no physical evidence in this case. Or the defendant agrees and the court orders that law enforcement may discard, destroy, or return all items of evidence set forth on the attached log, and that evidence will be released according to law enforcement agencies' procedures, and the defendant waives any right to further notification before the evidence is released. And then it says a photo ID is required to release the evidence, and if there's any evidence that Mr. Watts is going to have it released to, it's going to go to his father. Okay? So that's it. Do I actually think they're going to do it? Destroy anything? I think they're going to hold off and wait and see what happens. But anyway, that's it. Going to go live Monday. The plan is to be at the courtroom at the sentencing at 2 o'clock. Going to get there early, trying to get a good seat, get the emotion, the feeling, and be able to see exactly what is going on up there. All right, I appreciate you tuning in. I appreciate you watching. If you like the channel and you haven't done so already, please subscribe. Please hit the like button and hit that little bell for notifications so that you'll know when we're going to go live and when we put out a new video. As we've stated, obviously the Watts case will be coming to an end. There's other cases that we've been following, and I appreciate everybody's suggestions of cases that we should follow. There are just so many good, interesting cases out there. There's literally not enough time in the day to go through and discuss them all and get up to speed on everything so that we can provide the analysis. Like I said, our intent here is to be able to provide analysis and discussion beyond what you get on your local evening newscast, which is usually about 30 seconds, where someone who doesn't know the difference between a preliminary hearing and an arraignment is trying to tell you what you need to know. We're going to try to fill in that gap. I appreciate it. Thank you for listening. Thank you for tuning in. We will be back Monday. Have a great day.